that time in. Okay, good morning. Can you hear me? I somehow miraculously revived the projector. Hello? It's 10:40. I'm starting. Good morning. Nice to see you all. Okay, a couple administrative matters. So just to answer a question about office hours, they didn't happen this week. I was home with my kids. We had a snow day in the private schools, at least some private schools. So office hours will be next week. And let me just confirm the hours. We'll aim for Wednesday. Hold on here. Wednesday the 14th. No, that's spring break. What am I saying? Wednesday the 21st. It is the week before spring break. The day before spring break today. Okay. So Wednesday the 21st. Okay. We can do 1, 2, 3. Maybe 4:30 to 5:30, something like that. Okay? So that'll be office hours on the 21st. Okay. Just a couple quick words about the exam. Some of you have asked me, do not stress yet. It's not even spring break yet. But I just wanted to say a few words to guide you in your preparation for the practice exam, which I do think is wise for you to take over the break, because we'll be discussing it probably on Tuesday when we get back. I'm just going to say this again so that there's no confusion. The credit on the exam will be given in direct proportion to the amount of time we spent in class on any particular topic. Say it one more time. Credit on the exam will be given in direct proportion to the time we spent in class talking about material. That means that if there's a rule that we mentioned in class and spent no more than 30 seconds mentioning its existence, the most credit you can get for that on the final is for mentioning its existence. I figured it out. I'm a miracle worker. I had to keep pushing the button. Yeah. Okay. So that means that you won't get more credit for showing me that you, let's just pick an example. Oh, let's see. I was emailed a question about this. Let me pull an example from a recent email. Okay, Rule 137. How much time did we spend on Rule 137? Very, very little. Maybe I didn't even say anything about Rule 137. So I can't give you credit if you mastered Rule 137 and you write like a detailed analysis of how these facts are actually covered by Rule 137. It wouldn't be fair, right? It wouldn't be fair to the people who followed the rule, which is to study in proportion to the course material. So that means you shouldn't spend time studying material that wasn't talked about in class, and you should allocate your time to the material that we spent the most time talking about. So if I've reiterated to the point where you're nauseous if you hear investor protection one more time and things like overpayment, that better be in your answer, right? Like, I'm looking to see you engage with these ideas, like whether in a particular interpretation of the law would actually protect investors. So just to reiterate, that's what gets credit. So that means that study guides like outlines, a manual, securities in a nutshell, they may not be as helpful as you would think for this class because I'm not giving you credit for mastering material that we didn't discuss in class. I like to say this 5 times, but just there's no confusion, not just in May, but now when you start to review and you start to think about the practice question. Okay, what I like to see, what I reward, is really creative analysis. So you got to spot the basic issues, right? You need to know the material, but I'm not going to reward someone who just is like has an encyclopedic knowledge of securities law. Look, there's a reason the book is 1,600 pages or 1,700 pages, right? It's a massive area of law. there's no way we'll be able to cover all of that material, and I certainly don't feel like it's fair to reward those who are able to print in 4-point font on the notes or just have an encyclopedic memory. I'm looking to reward you for really good thinking, okay, which means you're going to use your brains and think about, showing that you understand the material, but that you really get what's going on in a particular fact pattern. The fact pattern on the practice exam should look familiar if you haven't seen it. It's sort of taken out of the news. That's always a good preparation for the exam because I'm not that creative, and I probably will end up just reading the news and writing a question based on some recent news. Okay, so it's not that hard. What is hard is to apply the material. It's actually a lot harder than you think to really get the intuition and the essence of what matters in a particular setting, and that's what I will reward. And it's 5 pages, double-spaced notes. Okay, so approach the practice exam in that spirit. Review the material, but don't stress about sort of perfect memorization of every little thing that we mentioned. Okay, focus on showing that you have a deep understanding of what securities law is really all about. That's the idea, depth. Okay. With that, today we are putting depth on the shelf. Yes, I'm sorry, questions, yes.
So 5 pages double-spaced or
Double-sided. Double-sided, yeah, double-sided. I'm sorry. Not double-spaced. Stress level in the room just started. No, double-sided, okay. I don't care if you do 4-point font, but it's not going to help you, okay? I mean, it's just not, yes.
just related to that, so we can't bring the book.
No books, 5 pages. Okay, letter size. Come on, guys. Letter sized, not A4, not magazine foldouts. Letter sized, 5 pages, print on both sides or write on both sides. That's it, okay? I don't care if you compress the entire book to microfiche size, okay? It's not going to help you. You have 4 hours to answer. You're going to get 2 essay questions. Oh, let me say something with multiple choice in a minute. But just to finish on the essay, you're going to get 2 questions. They're going to be long, like the one I sent you. You're going to have a lot of stuff to talk about. You don't want to waste your time sort of memorizing material. You don't want to waste your time looking up material. You don't want to waste your time memorizing endless quantities of material. You don't want to waste your time looking up endless quantities of material. You want to make sure you understand it. It's really not that hard, okay? But there is, in fact, a lot of detail and nuance that matters. It's not trivial at all what the right outcome should be. And what I like to see is that you show that thought, that you look at a situation and you go, I see the tensions here, and you can articulate a good analysis. Think in those terms. Okay, on the multiple choice, I don't know, I haven't decided how many. There might be like 5 multiple choice questions underneath like question 1, something like that, I don't know. They are going to be more sort of practice preparation, right? So the material we're going to cover today on exempted securities was what I remember being taught this new associate orientation, and it's sort of the bread and butter of practice, particularly Reg D. Huge practice area for large law firms. You need to walk out of here knowing like the difference between Rule 504 and Rule 506. Like that's stuff you need to know, right? You need to know what Section 5 allows and doesn't allow. This should be not that hard, but it should be something that you memorize and know because, when you meet a law firm partner and you say something like, oh, don't you know that, you can only have 35 investors under Rule 506, and they look at you like, what law school did you go to? Don't say you took SecReg with me, right? So you need to know this stuff, right? So the multiple choice, I'm just going to ask you questions around those rule-based material, okay? And for that reason, today we're going to go through a lot more rules. And this is just this part of the class where you need to know it. It's sort of the law. Not sort of, it is. Other questions before we embark on more of this? No? Okay. Exempted securities. Section 3A, so if you see here, I put up on the screen, which now works. Yes. Exempted securities. So this is long, and we're not going to go through all of it, but just an example, okay, what are exempted securities? Well, the provisions of this title, meaning the 1933 Act, should not apply to any of the following classes of securities. So now we're looking at a set of securities. We all agree they are securities, but these are excluded from the 1933 Act. And it turns out, by and large, at least parts of the 34 Act. So what's an example? Well, a security issued or guaranteed by the United States or any territory thereof, or by the District of Columbia, or by any state of the United States. So state and municipal securities are a classic example. What the book talks about is this constitutional concern that we don't want the federal government regulating municipal securities. What's a better reason for that? It's just the political process, right? So if you feel like you've overpaid for the value of your local government services, then you have a great remedy. It's called vote them out of office, right? So the idea that we have a political system to deal with these problems of overpayment in the political setting is not such a problem. Now, somewhere in this mass of text, here we go, or any security issued or guaranteed by a bank. Now, you saw this discussion in the casebook, page 336 and 37, that bank-issued securities are not subject to securities regulation. When you get like some banking lawyers in the room, like I had the privilege of working with Raj Cohen at S&C, who's just one of the best, probably the best of all time in banking. You get them talking about, like, at a cocktail party, you want to, like, impress them, so you're eating your shrimp poppers, and you're like, hey, Raj, tell me, like, why is it that securities issued by a bank are not subject to securities law? And Raj will go on for 10 minutes about how this is actually, like, the historical roots of banking and securities, like, stretch back to the New Deal, and actually, when you talk to lawyers in the space, like, one of the things banking lawyers really love to talk about is, like, the history of banking. It's a very historical discipline, like, they're into history. So this is actually historically sort of driven by the separation between banking and securities law. The idea that overpaying for a bank is kind of like putting your money at risk with a bank, and that's kind of like the thing we think banking regulators should handle. It turns out that if, I don't know, let's see, Goldman Sachs is a bank holding company. If a bank holding company like Goldman Sachs issues securities, are they securities subject to the 1933 Act? Of course, in the book, the answer is clearly yes. That's because a bank holding company is not a bank. Take FinReg to understand the difference. So that's fine. But what 3A2 is more used for, as the book explains, are these sort of securitized transactions, right? So if you have a deal where basically, someone buys a bunch of assets like mortgage loans that are not securities themselves, repackages them, that is, acquires them through a special purpose vehicle, which then issues equity or debt, generally debt securities, will be issued by a special purpose vehicle of that kind. Those debt securities can be magically taken out of the 1933 Act if there is a bank who will insure their repayment. And the logic for that is that the insurance itself transforms the contingent claim. It transforms the nature of the debt security, right? Because normally, debt securities carry risk. The risk is that the institution that issued the debt, the firm that issued the debt security, will not repay. It's credit risk, right? There are other risks, collateral risk and so forth, but credit risk is the biggest one. And if a bank is insuring the payments, then that credit risk disappears. It is, of course, replaced with default or non-payment by the bank, but that is just like a bank security, the kind of thing we think is subject to banking regulation or should be subject to banking regulation. And it turns out that if a bank goes under, we have FDIC insurance and all kinds of other ways to keep banks alive or to protect borrowers. And in fact, the question of what happens when collateralized debt obligations, CDOs, if you're familiar with those, or just asset-backed securities more generally, if you're familiar with mortgage-backed securities and what happened in the crisis. The question of how we deal with default in those cases when banks are on the line is really much more of a systemic risk kind of FinReg question. And that has to do with how we think about the nature of banking and who should regulate banks. We have, I would say, the best scholar in the country in that area, my colleague Kate Judge. I highly recommend you take her course if you're interested in that. But it's really a different set of considerations when a bank is on the line. Insurance companies, the book points out, did not like that so much. They wanted to also be in on the action. Recently, this isn't mentioned in the casebook because it's quite new, the SEC issued Reg ABS, which is a really interesting thing to read. I'm not going to go through it in detail, but there now is, in fact, mandatory disclosure for asset-backed securities. It's really cool, actually, because you can go and look at these form, ABS-EE filings, and they're like 200 megabytes. They're massive. You got to figure out a way to open them. But you can see, like, the Toyota Corolla in, like, Dallas, Texas, like, its repayment stream. That's why, because that car loan, you know, like CarMax. Have you heard of CarMax? So you can, like, buy a car from CarMax. CarMax finances the purchases of used vehicles, packages those loans that it's made to borrowers, and then what? And then basically sells them to special purpose vehicles, the CarMax Trust 5, you know, entity, whatever it's going to be called, that then issue debt securities. Those securities, if they're insured by a bank, are exempt from the 1933 Act. So CarMax wouldn't have to file an S1, right? This is not an offering of securities. However, asset-backed securities like those have been, in fact, subjected to new additional disclosure, which is centered around the loan cash flows, right? The repayment stream of the cash flows themselves. So you get all kinds of information like where the borrower is, not like their exact address, but their state, and another information about the interest rate, the payment streams. It's kind of cool. You can see like the Macy's at a particular mall isn't making their repayments. This is all fun, but has little to do with kind of classical securities law. The sense was that it is a security nonetheless, and it should be subject to disclosure. That's all I'll say about it. I actually think someone, maybe myself, should write a paper looking at these asset-backed securities. So if you're interested and want to co-author something, let me know. Okay, Section 3A3. Commercial paper exemptions. We talked about this last time. Basically, instruments that are commercial paper, that have a maturity of less than 9 months and arise out of a current transaction. So you've got this inventory, and you're going to issue very short-term debt, effectively called commercial paper. You can use 3A3 and escape SEC sort of formal disclosure, I should say, the requirement to file a registration statement and everything else that comes along with the 1933 Act. Again, the risks are of a different kind. There's this sort of debate over what a current transaction means. Don't worry, I'm not going to ask you about commercial paper on the exam. This is just to understand the contours. There's a charitable purposes exemption in 3A4. There's variable annuity exemption in 3A8. Okay. These are exempt securities, a small set of securities which we are exempting from the 1933 Act. Now, much more interesting material and what is the day-to-day practice of securities lawyers concerns transactional exemptions. So those, by and large, are not found in Section 3, although you can kind of read into Section 3 sort of a transactional nature in a few parts. But the main section we're going to focus on for the rest of today's class is Section 4. So let's read. The provisions of Section 5 shall not apply to 4A1, transactions by any person other than an issuer, underwriter, or dealer. Now, we spoke about this, bless you, we spoke about this in our conversation in the very beginning of the course around what is Section 5, what is the scope of Section 5, sort of who is governed by the 1933 Act. So bear in mind that the 1933 Act is a regulatory scheme designed to regulate the issuing of securities. Well, the 1934 Act has a different sort of scope, and it's really focusing on, it has its own registration scheme, which we haven't really broken down. We'll maybe talk a little bit about it after the break. But the 1934 Act is kind of about trading, okay, secondary market trading. The 1933 Act is not about secondary market trading. It's about issuing securities. And so it's very natural that 4A1 would sort of exclude from the 1933 Act transactions by folks in the secondary market. Another way to say this is that even though Section 5 prohibits offering to sell or selling a security, you're not going to be able to use Section 5 to prohibit secondary market transactions. You're not going to be able to say that a secondary market transaction is itself a violation of Section 5. You would need to pin down that secondary market transaction with some other basis for liability. Now remember that there are many other such bases of liability, including 10b, which we'll dive into, but also other statutes which we talked about, other sections of the 33 Act, which could in fact sort of get you, if you bought it from someone who bought it from someone who bought it from the seller. We talked about Section 11, 12, and so forth. So bear in mind that even if your immediate seller is not going to be violating the 33 Act, that does not mean that you don't have a right of rescission against the issuer for violation of Section 5, that then you might be able procedurally to pursue against your immediate seller, and the idea that they would then need to turn around to the person who sold to them. That will depend on the contours of the section you're suing under. But formally, Section 5 liability applies to the seller, to the issuer or the underwriter or the dealer. After the break, what we don't have time to do today is talk about underwriter liability. So there actually is secondary market liability under the 33 Act for underwriters and dealers. And in fact, folks sort of in the chain can get looped in and because they participate in this offering in some way and get characterized as underwriters. You saw that if you did the reading already. And in fact, this is a huge concern for the Spotify IPO, which is that by participating in the offering, and there actually is an IPO, and it'll be helpful to look at Spotify in light of this material, particularly the material we learn after the break. But if, in fact, you're participating in that transaction, you might be deemed an underwriter. So don't read anything I'm saying here as to suggest that folks other than the issuer can't be pursued under Section 5, but it's got to be because they're either an issuer, underwriter, or dealer. That's 4A1. Okay. 4A2 exempts transactions by an issuer not involving any public offering. Now this is the big one. The challenge here is figuring out what a public offering is. Now, public offering is not defined. So what is public offering for $200? Well, no one knows. No one knows what a public offering is. So what do you do? Well, the book explains that the history of this is that you wanted to be able to raise money. We wanted you to be able to raise money from your friends and family. You could go to mom or dad and say, hey, give me money. Invest in my business. I'll give you 50% of my business. That is a sale of a security, right? So remember, you're selling stock, and you're getting cash. So therefore, that transaction, the concern was, might get swept in to the scope of the 1933 Act, but we kind of don't think that all of those settings should be governed by the 1933 Act. That's at least the historical explanation. And the concern that, in fact, you might have investors who have the ability to sort of look into your business and kind of figure out what you're doing. You don't need the securities laws to protect those investors. And the book talks about how that's sort of one end of the spectrum underlying this idea of non-public offerings. The other end is the sense that even very established public companies might feel just fine sort of talking again to their investors who have bought securities over and over again. And we might have no problem with a sale in the context of, you know, hey, you're an ultra-sophisticated buyer like a Goldman Sachs. Could you, in fact, just take a look at my business, come on, you know, decide if you want to buy at this price, and with that, the transaction is done. In other words, the idea of a private placement kind of encompasses both the family transaction, which we feel like shouldn't really be subjected to these sort of disclosure rules, and the very non-family but nonetheless sophisticated investor setting. So those are the big sort of themes underlying this idea of not a public offering. Now, the book kind of gives you an overview of the evolution of litigation and rulemaking surrounding what it means to have a transaction that does not involve a public offering. The bottom line is that it was very unclear. It was very unclear, and the SEC subsequently issued what we're going to talk about in detail shortly, Reg D, to try and provide a safe harbor so that you wouldn't have to rely actually on the 4A2 exemption per the words of the statute. So the idea was that because there was so much ambiguity, and we don't have to go through each little piece of the historical evolution, but there was a lot of ambiguity around what it meant to have a transaction involving a public offering. So the idea was, let's promulgate a rule, and we'll break down Reg D shortly, that gives you assurance and certainty that if, in fact, you comply with these conditions, you will be deemed to have not issued a public offering. But before we really break that down, let's start by looking at the Ralston-Purina case. Because the Ralston-Purina case, even though it did not concern Reg D, kind of set the stage for Reg D's eventual emergence. And that's because what Ralston-Purina did was give you the judicial contour, so to speak, of the interpretation of 4A2. So what happened in Ralston-Purina, right? So they manufacture various feed and cereal products. And what they offered to their employees was the ability to buy what? To buy stock of the company at present market prices. Now, who remembers, did Ralston-Purina offer all employees the opportunity to purchase securities? No. Which employees? Yeah. This was like, in a way, kind of felt, I'm sure from their perspective, like not a very public offering. I mean, after all, you're sort of offering some particular employees the opportunity to buy stock. You think these folks are pretty sophisticated, at least one could argue, because they're in the company. They should know, you know, if they think the products are good, you know, they should know if the products are good because they made them, right? So there's this idea that, you know, your employees probably have a lot of information, and that information means they're less likely to overpay for your company than the typical investor. So it turns out that a lot of folks bought, including those who made $2,700 in 1949. We see so more or less, you know, a key employee was not an individual confined to an organization chart. Individuals eligible for promotion. In other words, it was kind of broader than maybe you thought when you first heard the description key employee, but it wasn't the general public. All right, we're all employees. So what does the court hold, right? So the holding is that to be public, an offer need not be open to the whole world. And after this lengthy poetic discussion of interpreting the private offering exemption in light of its statutory purpose, which is all great, the conclusion is that an offering to those who are shown, this is on page 349 of the casebook, An offering to those who are shown to be able to fend for themselves is a transaction not involving any public offering. So if you are an Eagle Scout, you can fend for yourself. Marines, right? You do not need the protection of the 1933 Act. All right. Well, in addition, on 350, the court concludes the focus of inquiry should be on the need of the offerees for the protections afforded by registration. The employees here were not shown to have access to the kind of information which registration would disclose. So what's the logic of Ralston-Purina? It's basically, you can read this lengthy sort of the design of the statutes to protect investors by promoting full disclosure. The bottom line is, look, there's a two-part test here. You need to be able to fend for yourself, and you need to have access to the kind of information that you would get under the 33 Act. So this kind of two-part test is trying to capture this story, right? So if you are, in fact, the Goldman Sachs of the world that are very sophisticated, and the company comes to you and says, hey, we'll open our books, we'll tell you anything you want to know, you don't even, the 33 Act would be superfluous. It would be unnecessary, right? Because here we are coming and volunteering all this wonderful information. And the logic goes, look, that should be enough, because essentially we're accomplishing the purpose of the 33 Act when these two conditions apply. All right. So these two conditions formed the basis of subsequent evolution of the case law around 4A2. And in the Hill-York case, was a sort of key inflection point where we see the Fifth Circuit taking a very aggressive stance as to what the required information is. I'm just going to read. The court approved the trial court's jury charge that every offeree had to have information equivalent to that which a registration statement would disclose. So even if the offerees were lawyers and businessmen, your sort of sophisticated can fend for yourself offerees, if they did not possess the information required to be contained in a registration statement, they could not bring their sophisticated knowledge of business affairs to bear in deciding whether or not to invest. So Hill-York sort of read these two requirements from Ralston-Purina in a pretty strict light, kind of saying, look, you basically have to give these sophisticated buyers the equivalent of a registration statement. Now, that's a very high standard. Then, in the bombshell decision, Continental Tobacco, as the casebook describes it, the Fifth Circuit went further, holding that even if the prospectus sent to the purchasers contained all the information that a registration statement would, if the purchasers don't have the opportunity to inspect the corporation's records or to verify the statements made in the prospectus, then if some of the purchasers have never met any officers of the company, then they don't have access. So we're going to require not only that registration statement information be disclosed, we're going to require that, in fact, you have given actual access. So you've gone and met these investors, and you've opened the books, not just given them the opportunity to read the books, but you've opened the books. Well, that's even higher of a standard, and more or less would have killed the private placement exemption. So that was not sort of what folks liked. So then we got Doran, right? So in Doran, the Fifth Circuit kind of dialed it back a little bit and pointed out that, in fact, availability under Ralston-Purina of information can mean, this is on 357 of the casebook, either disclosure or effective access to the relevant information. So you could satisfy this standard by what? Well, 358 explains, when the issuer relies on access, absent actual disclosure, he must show that the offerees occupied a privileged position relative to the information, relative to the issuer that afforded them an opportunity for effective access to the information that registration would otherwise provide. When the issuer relies on actual disclosure, he need not demonstrate the offerees held such a privileged position. In other words, it's not a requirement, Continental Tobacco's suggestion, that you have to go out and meet all of the business folks and have this sort of tour of the facility before you can enjoy the private placement exemption. That's not actually the law. Those were just the facts of Continental Tobacco. And it turns out that providing access to the information saying, hey, you want to inspect our books, that's enough. If you disclose the information in the registration statement, that's enough. But at the end of the day, we're going to loosen the standard a little bit while keeping it still ambiguous. You don't have to be an insider, right? The court points out. The bottom line is that the contours here are pretty unclear, right? You need to sort of show that they have both sophistication and some kind of access or disclosure, or effective access and disclosure, and that is messy. Okay, does everyone get this? This is how the case law is evolving. So, formally, just to reiterate, under 4A2, you need to be able to show that if the information required in a registration statement is not disclosed, the law would be that, the law is that you have to show either effective access. Let me say that differently. You have to show that effective access was given, and in order to establish that effective access was given, you have to either show that there's some kind of insider status or relationship, special relationship of some kind, and the question is whether the offeree will be able to use that relationship, right, to exploit that relationship to obtain access to the information. So it's not enough to just say, yeah, we told them that if they called our investor relations hotline, they could learn anything they wanted about the company. I mean, maybe that might be enough, but what if they call up and the secretary isn't very helpful? So these facts kind of move us away from establishing access, right? We want very clear facts. We want to know what access is, not what may or may not be. And that's why 4A2, as a matter of law, is somewhat murky. Okay, any questions on this? Are we all on the same page? This is sort of history. I mean, it is the evolution of 4A2, but 4A2 is actually never, very rarely, directly relied upon in practice for these reasons. It's just not clear whether you can establish in any given case that under the statute there is, in fact, sophistication and effective access or disclosure, even though those are the elements, because you can almost always kind of bend the facts one way or the other, particularly on the access point, which then transforms 4A2 right into effectively a disclosure regime that is duplicative of the 33 Act itself. Okay, does everyone get this? So 4A2 kind of fell out of favor. It's not really useful. When companies are raising cash via private placements, they want certainty, right? So what happened? Well, Reg D happened, okay? So Reg D emerged against the backdrop of this very unclear case law concerning 4A2. So Reg D. So Reg D is kind of reprinted in large part in your casebook. It's that important. It is important. It's very important. I promise you there'll be a question on Reg D, pretty much, right? It's important. So you need to know it. So Reg D. So Reg D has 3 key operative rules, all right? 504, 505, 506. 504. What are the conditions for 504? You just have to read them off of 371 of the casebook. 504 is the small issue exemption, right? How much can you raise under 504? Someone shout it out. Million, exactly, $1 million. You can raise up to $1 million. And how many people can you raise money from under 504? No limit. Perfect. So 504 is basically, I got an idea, and I'm going to go to Shark Tank, and I'm going to get a $500,000 investment from Mark Cuban. Do I need to register that security under the 1933 Act? This could be a multiple choice question. Just like that. Joe goes to Shark Tank, strikes a deal with Mark Cuban. The terms of the deal are as follows. In exchange for 50% equity of my company, you will give me $500,000. Joe hasn't raised money from anyone else in the last 12 months. What exemption applies, if any, to Joe's transaction? And your answer should be $504. There we go. It's not going to be that hard. Maybe a little harder, but that's it, right? So 504, small issuing exemption. 505, higher threshold. What's the threshold for 505? 5 million. Beautiful. How many investors can you have? 35 unaccredited. Good. Exactly. How many accredited? Right. So is 505 useful? Well, more useful than 504, because you can raise a lot more money. But it's not as useful as 506, right? So there's a couple minor sort of differences between 505 and 506. But 506 kind of copies the 35 unaccredited investor provision. Well, it just sort of structurally is a little different. It says you can sell to 35 purchasers, but accredited investors don't count. In other words, you can also have an unlimited number of accredited investors. And why might you prefer 506 to 505? There's no cap, exactly. Okay, so there are no limits to Rule 506 transactions. All right, questions so far? This is pretty straightforward. So the vast majority of Reg D, or private placements, are in fact conducted under Rule 506. Now, I wanted to show you, because I always thought this was cool and also understudied. Again, for those of you who are thinking of paper topics. You can actually go, anyone been to Edgar before? Does everyone know what Edgar is? This is sec.gov. You go to company filings, daily filings by type, and you can punch in D. I always thought someone should write a paper on this, but nobody has, or not many. And it turns out that you can actually see all of the Reg D transactions for which a Form 4 has been filed. Did anyone who's really pedantic and has a lot of free time read as to whether a Form D is required? The filing of a Form D, is it required when you do a Reg D transaction? Does anyone remember? Do you remember? That means you're really, really good reader.
The answer is no, right?
Why is it no?
Form D, or you can file or you can furnish Form S1.
So you have to file, so the SEC says you have to file Form D, but what happens if you don't file it? Does anyone pick this up? Yeah, right? Mm-hmm. So they had proposed, like a true right of rescission for the transaction, putting some teeth on the Form D filing requirement, but that was subsequently abandoned. That was a long time ago, I guess like 10 or more years ago. So all of these are good citizens, which kind of makes it hard to interpret. I guess the bad citizens don't file. But anyway, so if you look, So let's look for, I don't know, a lot of people are sick, so Sick Weather Inc. Here we go. So Sick Weather LLC, oh, that was their previous name, okay. Sick Weather Inc. is a Maryland corporation on 101 North Haven Street, Baltimore, Maryland, Suite 301, founded by Dodge Graham Dodge, James Sager, Michael Belt, Zephyrin Lasker, John Fine. In the other technology industry, they declined to disclose the size of the transaction. That's useful. And they're claiming under Rule 506C. Okay, so what do we learn from this? We learn that you can invest up to $500. They raised $1 million. Well, the size of their offering was $1 million. They raised $654,000. I'm not sure if you can actually see that. They raised $654,000, and they still have $345,000 to be sold. The broker-dealer affiliated with facilitating the transaction was SI Securities, and they made $47,000 on the deal. That's kind of cool data. I'll do something with that. Anyway, so this is fun. There are thousands of these filed every day. And I just thought this was kind of interesting because if you think that the most important economic activity happens in the private sector, here's all kinds of cool data about private sector financing. Private placements, Reg D filings. Okay, any questions? Does everyone understand what a Reg D is, what a Reg D does? Okay. What is an accredited investor? 501. Yeah.
I feel like I might be going insane.
Yeah.
Maybe we're going to get this.
Yeah.
Wasn't Rule 505 like disengaged by the commission and it was replaced with Rule 404? They bumped it up to 5 million and they got rid of 505.
Did they get rid of 505? Is our casebook out of date?
I'm looking it up and it says on October. I'm now reading from Wikipedia, but I saw a longer one.
Well, there you go. Why did you go to law school? Let's just read. Okay, Wikipedia.
But it says on October 26th, 2016, the commission repealed Rule 505 as previously
Yeah.
5
There you
million,
go.
and it moved the 5 million to the limit for 504.
See, our casebook is out of date.
Also, if you go to the SEC site, it confirms that.
Yeah. But it was just.
Yeah, I think the book was published after this.
Yeah, the book was published after. Don't you love that? I know. That's why I said to Jack, Jack, your book is up to date, right? He said, oh, yeah. Yeah, look at that. So much for Rule. Definitely not going to get a question on Rule 505.
Be a good trick question.
Yeah. Okay. Cool. Yeah. All right. What was I doing in 2016? Clearly not following the SEC's website. All right. So no Rule 505.
Well, you were right, 506 is more useful.
It's definitely more useful. That's great. I got to tell Jack that. His book is completely out. But wasn't it just revised last year, his book? Okay. That's great. All right, no 505. Okay, 501. What's an accredited investor? Let's rely on our book. What's an accredited investor? Okay. Let's make sure. Release number 6455 repealed? No. I thought you guys just catch all of these like mistakes in live in real time. Here we go. Nope. I think we're good. All right, 6455. Okay, the definition of accredited investor includes any person who comes within or who the issuer reasonably believes comes within one of the enumerated categories at the time of the sale of the securities to the person. What constitutes reasonable belief will depend on the facts of each particular case. For this reason, the staff generally will not be in a position to express views. All right, so there's a nice Q&A. So basically, institutional investors, that's good. That's good. What else? Who else is an accredited investor under 501? Well, natural persons. Let's actually look at the text of the rule. This is actually quite important. This was a debated topic. All right. Okay. Any natural person whose individual net worth or joint net worth with that person's spouse exceeds $1 million, except as provided in paragraph A5(2), for purposes of calculating net worth under this paragraph, the person's primary residence shall not be included as an asset. So basically, you need to be a millionaire, not counting your house. All right. So if you're a millionaire, not counting your house, or you had you're a natural person who had an individual income in excess of $200,000 in each of the 2 most recent years. So you got to be wealthy. All right. So you either got to have a lot of assets or you got to be wealthy. Now this is actually really quite key, right? And so you see there's some Q&A around, I don't know, is a corporation with a net worth of $2 million, is they an accredited investor under 501A5? No. We learn 501A5 is limited to natural persons. In calculating net worth for purposes of 501A5, may the investor include the estimated fair market value of his principal residence as an asset? Yes, Rule 501A5 does not include any of the purchaser's assets from the net worth needed to qualify as an accredited investor. Didn't we just read the opposite? Let me look back up. Yes. Indebtedness. Oh, no, the person's primary residence. Was that also revised? Wow, this is quite out of date. Okay. In calculating net worth. Oh, except as provided. Here we go. See, this is why you got to read the statute. Okay. Except as provided in paragraph A5(2) of this section, for purposes of calculating net worth, the person's primary residence shall not be included as an asset. But what is provided in A5(2)? A5(2). Oh, this is a sunset provision, I see. Of this section will not apply to any calculation of a person's net worth made in connection with the purchase of securities, provided that such rate. Yeah, so this is also out of date. So there was a time when, in fact, you could include your house. You can't anymore. As you can see, this is out of date. All right, just like Rule 505. I'm going to tell Jack, these pages are out of date. The supplement's update. Oh, that's what he's going to say. It's in the supplement. But this was printed anyway. Okay, general solicitation. Let's move on. General solicitation under Reg D. So this was actually a big deal, right? So this is going to lead into our discussion of crowdfunding. All right, all this minutia is not that important, but Reg D, but general solicitation is important. So the question here is, so you want to advertise your offering. And I remember post the Dodd-Frank Act, there was a lot of question around how broadly can you advertise private placements, in part because the ban on general solicitation was repealed for 506 offerings. And the idea was, look, maybe now what you're allowed to do is to go out there and advertise that you, in fact, are making a Reg D offering. One reason folks thought this was important is because the sense, one of the things that led to the Jobs Act was the sense that, in fact, you don't have as many vehicles to raise capital if you're a small business. And the concern that general solicitation is quite important to accomplish private placements led to the release, did I say the Dodd-Frank, the Jobs Act in 2013, the SEC released final rules which were either required an issuer to avoid a general solicitation or take reasonable steps to verify that purchases in such an offering involving a general solicitation are accredited investors. So more or less, you're allowed to conduct a general solicitation in a 506 offering, but, and this was really the issue that people were talking about, how do you make sure that only accredited investors view that general solicitation? So classically, right, you saw this in the book, you could conduct a private placement on a password-protected website that you only gave the password to individuals who could establish their net worth. The question is, okay, so suppose now in this new world of general solicitation being allowed under 506, if you can advertise your offering, how do you make sure that the advertisement is only seen by accredited investors? So there's this tension, right, between how do I get the ad out there, how do I get it out there in a way that only, that only allows purchasers to be accredited investors, so I can advertise that I have this private placement, but I'm going to then require proof of your income to participate. Kind of takes us back to a world where you're still going to be a little bit cautious as to who you tell about this transaction. There was this real concern that, in fact, it's going to be very hard as a seller to really verify that information once we open up the can of worms of general solicitation, right? So general solicitation, advertisements, websites, things of that nature. The problem is, how do you know, right? So someone comes to your website and they enter their date of birth and their income level. How can you verify that? How can you be sure? You could say, check the box, I am an accredited investor. That would probably not suffice under these guidelines. And the problem is, like, well, you could ask them for their income, but you haven't verified it. But yet you're sort of making an offer to sell securities. Now, at the end of the day, you can require that before you actually sell, there's some verification, and I think that's the approach that most are taking. But you're going to want to satisfy this safe harbor, so you're going to want to show that along the way you didn't ask for their income, you tried to take steps to verify that they are, in fact, sophisticated, right? That they have these that they cross these minimum income thresholds. So general solicitation is an interesting question because it kind of tees up the crowdfunding debate, which is, look, you think of crowdfunding as the ultimate form of general solicitation in which you are advertising an investment, equity-based crowdfunding. We'll look at the crowdfunding rules in a minute. You can think of that as sort of the extreme form of general solicitation, in that you're not only making an offering known to the world, you're inviting participation in the offering in a completely non-screened manner, right? So you are sort of point and click participating in the offering. So it's kind of the extreme end of general solicitation. And the question is, look, where do we want to draw the line? And this is more interesting, I think, between sort of broad-based participation on the one extreme, which is really what crowdfunding is, and this kind of closed world that governed Reg D transactions previously. And the ban on removing the ban on general solicitation was kind of trying to strike a middle ground. So say, look, we'll allow you to advertise, but you still have to verify. All right. So what else? So more or less, that's what you need to know, in my mind, more than you need to know about Rule 504 and 506. You definitely don't need to know anything about 505. And bear in mind, so this is in 394, was a proposed rule that would require the filing of a Form D. This is our interesting conversation around whether there's any penalty for not filing a Form D. Blue sky exemptions, there's this discussion, 395. The advantage of a Rule 506 offering is that it's a covered security and thus exempt from blue sky. What is blue sky? What are the blue sky laws? Well, there's a blue sky workshop here held on Mondays. This is not referring to the blue sky workshop. It is referring to state securities laws. And yeah. So more or less, 506 offerings are out of state securities regulation. Okay, Reg A. Trudging through here. Reg A. So Reg A, the parallel regime. A plus now, more popular, and a little bit anyway. And these are, we're not going to spend too much time on them. Just very similar to Reg D. The idea is that we're going to allow some offerings to be made to some investors under some circumstances. Actually, the idea behind Reg A and A Plus was to remove which investors can participate. So the theory here was that we'll have an alternative exemption regime that's just for small issues, but we're not even going to worry in this regime about the number of participants. We'll just allow everyone to buy in. And in fact, so in this way, we'll be able to actually do an IPO, right? So we'll be able to do an IPO underneath the auspices of a trimmed-down disclosure and compliance regime. A plus really sort of became a little bit more popular, and the idea is that if you comply with some of these requirements, you can raise only up to $50 million. It's not that useful, but it is more useful than $1 million. You can, in fact, enjoy unlimited trading. One of the things about Reg D offerings, we'll talk a little bit more about this next week, is that they are restricted securities, so you can't resell a Reg D security to members of the general public. But with Reg A, you can. Reg A, you can have a liquid trading market. So the idea was, look, if Reg D reflects a sort of trade-off of less liquidity but more investor protection because we're giving more information in these sort of highly negotiated private placements, Reg A would be the opposite trade-off. We'd say, look, we recognize there's less information because it's not negotiated. We're going to allow trading, but we really justify this by pointing to the small issuer nature of these, right? So this is a small amount of money, so we don't really care. Like, I mean, if you lose, a few $1,000s participating in a Reg A plus offering, not a big deal. You can't raise more than $50 million total, so we'll let these sort of mini IPOs move forward. We talked earlier, I think together, or one of you sent me an email, that Reg A plus IPOs are on the decline, or not as, we talked about mispricing, right? We talked about A plus. There was this nice article that we talked about together. Well, here we go. Why regulation A plus IPOs should be avoided. This is one investor's opinion. Let's see why. So, there's the 50 million cap. And non-accredited investors can invest up to 10% of their annual income. Everyone got excited about crowdfunding. So remember, this is sort of this spectrum here. Look, the fact is that these Regulation A plus IPOs are not of the caliber that serious institutional investors would be interested in. This is what you read everywhere. So the idea that you'd go out and raise money from kind of stupid retail investors wasn't so appealing to companies. Remember, we talked about this in the mispricing conversation. It's not so trivial to bear the risk of buying an IPO, and it's not at all clear, as we saw, that these markets are priced correctly. So Reg A Plus is not that popular, again, but it is something you should know exists. Okay. These are the exemptions. What I can tell you is that the more interesting one is actually crowdfunding. So let's talk about crowdfunding. So crowdfunding is kind of interesting because crowdfunding became, it was actually really hot. If you remember, there was, I guess maybe 4 years ago or so, there was a lot of conversation around crowdfunding as really democratizing raising capital. The idea that we don't have to work through large investment banks. And the SEC issued, in fact, regulation crowdfunding. Let's look at it. So regulation crowdfunding, I think crowdfunding is more interesting, not because it's actually used by any of the law firms that you will go work at, but because it's more sort of analytically interesting. It's kind of one that you can think about a little bit more. So regulation crowdfunding enables eligible companies to offer and sell securities through crowdfunding. The rules permit a company to raise a maximum aggregate amount of a little over $1 million through crowdfunding offerings. So you can't raise a lot of money, but this is kind of interesting. So let's just let's just reiterate, well, this is very long, but let's just reiterate what crowdfunding is, okay? So an issuer may offer or sell securities in reliance on Section 486 of the Securities Act, provided that it doesn't exceed 1 million, and in fact, there's this income threshold, all right? So there are some limitations, there are some calculations, but why is crowdfunding interesting, right? Well, if you think that the sort of engine of the economy is these small startups of the kind that go on Shark Tank, you might think, well, you know, we want to make it easy for folks to raise initial seed capital in small transactions. So regulation crowdfunding made sense from that perspective. Crowdfunding traditionally was not an equity transaction, right? If you realize the pre-regulation crowdfunding, what crowdfunding was basically just buy my product and I'll use your pre-ordered, you know, I'll use your pre-order payment as working capital for my business. The sense was, look, you know, that may or may not be so fair to these investors. I mean, you know, you could offer equity too, and these investors would give you more money. And so regulation crowdfunding allows for equity-based crowdfunding, but because it caps it at a $1 million ceiling, you can't really raise money for a very exciting business that way. Still, it's kind of interesting because crowdfunding is, like I said, this kind of extreme trade-off where you say, look, I'm going to allow more investors, actually the entire world, to participate. Now, I think it's kind of cool to think, all right, so if we have a bunch of people who have very small economic risk, is that better or worse than what we get under Reg D, which is more or less a private placement market dominated by some large players? Now, this part of this conversation is, at least to me, the most interesting, which is to think, look, there's a trade-off here, right? The trade-off is you can have a lot of, you know, what does it mean to sort of have a democratized funding, like to have a bunch of small investors? It means that any investor's single economic exposure to a particular firm is limited. So if we take that back to our framework around informed trading and liquidity, say, look, you know, in a way, what crowdfunding does is kind of take away the potential to negotiate with your investor for a share of the profit that derives from like informed listening in this way that we've been discussing. So you can't really contract, one way to think about it is, with your crowdfunding participants. As a result, there's no one who has, you have like a collective action problem, right? Every participant has such a small economic exposure. They also have a small economic gain. And so they're not going to incur many costs in figuring out what's a good or a bad investment. So if you think about it from that perspective, you say, okay, look, what regulation crowdfunding is trying to do is to say, look, there's a lot of companies out there who aren't going to get capital unless you go about this, you know, this non-intermediated system, but intermediaries perform an important function. So the policy question here, I think that's interesting, is if you take out intermediaries, is that actually better or worse for investor protection? So having gone through all the rules, and you know the basic contours, and you're better at me at figuring out what rules exist and don't today, I would push you to think about the implications of private placements and whether or not they're good or bad. What I mean by good or bad, so is it a good idea to protect investors through private placements? Remember that private placements can also be used by publicly reporting companies under the 1934 Act that have a market price. So the interesting puzzle, I think, is to say, look, you know, as between a world where a company goes out and gives information via an IPO and a world where it raises funding through private negotiations, what are the costs and benefits? And we've often said that a justification for public equity markets is that by participating in these markets, there's greater liquidity for the firm's shares. What we've seen is a decline in IPOs, right? We've seen a massive decline in the number of US-based IPOs. an increase in deregistrations, delistings. What does that tell you? It tells you perhaps that the public equity markets, as we've envisioned them, aren't necessarily working as well as some investors would like. So think about the exemptions in light of that problem. So the exemptions are like pressure relief valves, is how I think of them, right? So you have this problem that if you want to go public, you know, the 33 Act is this draconian regime. It's not just about cost for small issuers. It's also, you know, it cost is a huge part, but it's also, there is this problem of having to be large enough and having to have the right connections and making sure that Goldman Sachs will return your call when you give them a call, right? And so there is a sense that by opening up the capital markets, what we're doing is facilitating capital raising transactions. On the other hand, we're taking away the role of intermediaries, like the underwriter, right? Go back to Section 5, whose job it is to ferret out what the firm is worth. So it can be hard, even for me, to keep in mind these broad goals when we're sort of in the thick of this, but keep them in mind, right? Because if you want to understand why equity crowdfunding is or isn't a good idea, why there doesn't seem to be so much excitement about Reg A+, there's a reason. And I think that reason is much more interesting than all the detailed nuances, which you'll need to know if you work in this area. But the reason why there is a preference for Reg D in private placements isn't just about transaction caps and transaction limits. It's about the role of information processing in capital markets. And the idea that we take underwriters out of the equation, that we take out intermediaries, isn't like a cure-all, right? I mean, a lot of the push to reform the IPO process that we still see today is driven by this assumption that you hear over and over again that the costs of going public are just too high for public companies. But so are the benefits, right? There are a lot of benefits to having underwriters, to having intermediaries. So when you take out intermediaries, when you start placing, when you start doing private placements, when you start raising capital in the private markets, or you have kind of these hybrid regimes like Reg A+ or equity crowdfunding, you are removing ingredients of the Section 5 process that we thought mattered. And this is what I think is important, right? And this is what I want you to be thinking about and take away from this class. When we broke down Section 5, and we talked about Arvida, and we talked about Chris-Craft, and we talked about Texas Gulf and materiality, and all, we had this entire story around like the role that each actor played in the process. And now we come to these pressure relief valves, right, where you can raise capital without following that process. And my suggestion is think about the benefits of Reg A+ or crowdfunding or even Reg D. Think about them in light of what they are taking away from the Section 5 process. That's, I think, the interesting point. When you take away a particular component, something changes. And that's why you see articles like equity crowdfunding is not for real investors. Institutional investors are avoiding these. Why? I mean, if that was so clear, why were these rules enacted in the first place? Why did Congress embrace equity crowdfunding if it was so clear that no serious investor would participate? So these are puzzles, right? And one way to view securities law, and I'll leave you with this for the break, one way to view securities law is like my job is as the lawyer in the Corp Fin group to get this transaction right. Some of you really like that role, and you're unhappy with some of the policy sides of this class because you really want like the checklist. But this is a huge practice area, right? It's 1,700 pages in the casebook for a reason. That's because there's a lot of securities law that's also about litigating what kind of information should be out there. And it's also about policy making, what sort of information we need for our capital markets to function. And it's also about institutional design. Which role should each actor play in the process? So I think those are all the questions we should be thinking about, and you should be thinking about over the break. Every actor in this process plays an important role, right? The underwriters play a role. The SEC plays a role. Litigation plays a role, right? And so when you think about the law in this area, don't think about it, at least that's for this class, as just a series of requirements and rules that have to be satisfied if you want to go public. Think about it as a series of institutional design choices, right? We're choosing to embrace one kind of institutional design over another. We're choosing to have an institution called underwriters in some settings and not others. And those choices have huge effects on our capital markets, right? So I'll leave you with that. If there are any questions before we head out to the break? All right, so keep in mind, just again, as you look at the exam hypo, as you think about summarizing the material, the much more interesting questions for me, at least, for this class are these questions of institutional design. You know, it's not just an accident that we have the law that we have, and it's not just a series of checklists. It reflects difficult trade-offs, okay? So think about that, and that's actually question 2 on the practice exam, which is to talk about those trade-offs. So with that, have a wonderful break. I'll see you on Tuesday the 20th. Yeah, absolutely. What's up?
The case law for exemptions that we were looking at
Yes.
at the beginning, is this still good law? Because I understand that the Reg
Well, it's
D
evolved,
kind
right.
of took the field. But at the
Ralston
same time-
Purina is good law. I mean,
Yeah,
that
it
is
still remains-
that is the law of 482,
Yeah,
but
so
it's just
that's-
never used, right?
Because
Because if you have Reg D, you're just going to rely on Reg D.
Yeah. Okay.
Hey, what's up?
Back there, I think Madeline might have asked the same question I'm going to ask, but that whole line of case that started with Purina is still good law. It's just not used, right?
It's not used. Nobody uses 482. Like, it's so uncertain, right? I mean, did you give access? Was there effective access? Were they sophisticated? I mean, maybe the Reg D sophistication standard will get read into 482, but it's an open-ended area. It's not litigated heavily because nobody uses it.
So practically, Reg D is like
Practically Reg D is it. Yeah. I mean, there's, for any serious practice, I mean, there is crowdfunding, there is A+, but they're not what your large law firms that, like, most of you would be going to would be doing, but they do exist as well.
So for crowdfunding in Reg A+, you wouldn't use like the Ralston Purina line of case to analyze that.
No, you wouldn't, but they are alternatives to the private placement, right? So if you think, like, I could rely on the statute, or I could choose from a menu of 3 different, safe harbors in a way, right? So Reg D is a safe harbor, A+ is a safe harbor, crowdfunding is a safe harbor. I'm going to pick one of the safe harbors. I'm not going to go to an ambiguous statute.
Gotcha.
Right? Does that make sense? Yeah. Hey, Davey, what's up? Yes.
First one being, okay, in the text of page 3, yeah. So you were talking about it a bit in class, but I still didn't really get it. Like the 3A2 and like
Insuring the loans.
yeah, like the structured finance and asset-backed securitization
Yes. Yeah. So which part of it?
Like,
The whole thing, or which?
what do they do? What is the bank doing for these?
So you have a bunch of car loans.
Yeah. So
Okay.
I got the like the asset.
Okay, you know what an asset-backed security is.
Yeah, like
The bank insures the payments.
Yeah. So that's.
So if there's no payment, the bank will pay.
Okay. Oh.
Does that make sense?
I looked at what it was written. It was really
Does that make sense? So
Yeah.
if they don't pay their car loan, we will pay the investor.
Okay.
So that makes it a very different kind of security, right?
Okay. Yeah. That does. Okay.
Yeah.
Oh gosh, I really sat there last night. Like, what are you talking about? Like, I sort of, but I don't. Okay. Okay. All right.
Good?
So yes.
Anything else?
You know, I'm gonna wait and ask her the other question because I did.
Come to office hours.
I went for that day when the students were there,
Oh.
students, and then I don't know if
I'm
something
sorry.
happened and stuff, whatever. So I was like,
I'm sorry.
no, it's fine.
But the 21st
Yeah.
should work.
The 21st, okay.
Looking
So
forward to it then. All
great.
right.
Thank
see
you.
then.
Enjoy your break.
Yeah, you too.
very plugged into the space. And something that's fundamentally changed in the ecosystem is and that is that this layer 2 protocol has gone live that's built on top of Bitcoin called the Lightning Network. And what the Lightning Network does is it solves the off-sided use case of paying for software paper. People used to think about Lightning Read
Okay. Okay. All right. I'm just gonna just really quick.
Yeah, no, we want it physically in terms of us. Yeah, so, you know, it's awesome. That's amazing. Okay, sorry. So, got it. So then you want to talk about it. So with that said, I realized that.
Which file is it? The PowerPoint?
It's
Is it?
the PowerPoint
this
one?
one?
Yeah.
Right.
So I've been talking.
It must have been when they left the room. They didn't mention the
You might wanna keep that. People leave it behind.
Yeah,
Right?
okay, thank you. I'm glad you copied it. That's an easier way to do it.
It is this one here.
With a broader mission to continue doing this and create an evergreen fund to continue doing this.
This clicker here, you can.
Oh, I see. So I don't have to be like that.
Yeah, you can see it.
Okay.
Is that all you need?
I think that's good. Is there anything? Let's see. Just this and that.
Yeah,
This is
and
forward.
that, that's all, yeah.
That's
And
backwards.
That's all.
Okay.
Do you need a lavalier mic?
I don't think it. I think we just encourage people to come up. I don't think I need